The turning point for religious liberty in this country was clearly the Mergens case involving Bible clubs, because it set a different tone. It said no longer will expressions of faith be removed from the public school as if they were somehow subversive or against each other. And that changed the way people thought about religious practice and religious faith, not just in schools, but then across the board.
We wanted to have the Bible study meet in the school, and we thought it'd be no problem to start. But it turned into a problem when the principal said, no, you can't have it.
They may not meet under the present ruling of the Court of Appeals for the Fifth Circuit if that speech involves some sort of religious thought.
Mr. Sekulow, but you would make this exception to your curriculum. You would consider it to be part of the curriculum if the school is devoting a substantial amount of its resources specifically to running or directing the club. For instance, if it doesn't have a music course but has a school band and pays a conductor of the school band.
Your Honor, I see my time has expired. May I respond?
You may answer the question.
Thank you, Chief Justice. In that particular situation, I think it would have to go beyond just expending resources. There would have to be something more where there was instruction going on, or else, in fact, it would just be nothing more than, if you will, another club. But there would have to be something during the curriculum where academic credit was given, supervision of a teacher, and these type of things. As Justice Scalia stated, that's specifically what the Equal Access Act, and granted, some of their policies, many of their policies, were before the adoption of the Act. But I would find it very difficult I'm in fact perplexed by a school not allowing a young Democrat and a young Republican club to meet on campus.
The only thing you've said so far is that it has to be sort of a direct relationship, and then you look at the legislative history and you're bound by the legislative history.
No, Your Honor, absolutely not. What I am saying is this, and let me do this by example. For instance, a French
Justice White doesn't take much of legislative history, Mr.
I've heard that. There are other members of the court that don't as well.
I've been reading subversive literature.
In Mergens, the court said that when students talk about God, there is no violation of the so-called separation of church and state. The court also said that handing out Christian literature is protected by the First Amendment.
It's called pristine speech. It's the highest form of First Amendment activity. The distribution of religious literature on a public school campus is protected, because religious literature distribution has always been protected. There was no way. That's what the world said, that you'd have prayer and Bible studies back in a public school. No way. And then the decision came out. And it wasn't just a little victory, it was 8 justices out of 9. What does that say? God answers the prayer of his people.